As humanity extends its activities beyond Earth, law becomes not only an essential regulator but also an conduit for expressing our collective moral values. Legal frameworks provide the normative scaffolding within which space ethics must operate. However, just as terrestrial laws has often lagged behind technological innovations, space law too faces the challenge of remaining relevant, enforceable, and ethically coherent in an era of rapid change. In this section, we examine the foundational legal documents that shape space activities, assess their limitations, and explore how they interact with the evolving moral imperatives of space exploration. The most important and widely accepted legal foundation for space governance is the Outer Space Treaty of 1967, officially titled the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. This landmark treaty emerged at the height of the Cold War, when fears of militarization in outer space prompted the international community to preemptively establish certain limitations on sovereign behavior beyond Earth's atmosphere. The Outer Space Treaty was adopted under the auspices of the United Nations and has been ratified by over 110 countries, including all the major spacefaring nations. It enshrines several critical principles. Firstly, it declares that the exploration and the use of outer space shall be carried out for the benefit and in the interest of all countries, regardless of their level of development. This establishes space as a domain of shared interest and common concern. Secondly, the treaty explicitly prohibits the national appropriation of outer space, including celestial bodies, by the claims of sovereignty, use, occupation, or any other means. Thirdly, it mandates that activities in space be conducted exclusively for peaceful purposes, expressly prohibiting the placement of nuclear weapons or other weapons of mass destruction in orbit or on celestial bodies. However, the treaty imposes responsibility on states for both governmental and non-governmental space activities. States must authorize and continuously supervise the activities of their private entities, ensuring that such actions remain in conformity with the treaty. This clause creates an indirect mechanism by which commercial actors such as private corporations involved in satellite development or resource extraction are held accountable under international law via their home countries. While visionary in this ambition and noble in its principles, the Outer Space Treaty is not without shortcomings. Its language is often vague and open to conflicting interpretations. For instance, while the treaty bans national appropriation, it does not explicitly prohibit the ownership of extracted resources. This ambiguity has been seized upon by some nations to develop domestic legislation and permits private ownership of space-derived resources, raising concerns about legal loopholes that permit de facto appropriation under the guise of commercial exploration. Furthermore, the OST lacks robust enforcement mechanisms. There is no centralized authority empowered to monitor compliance, adjudicate violations, or impose sanctions. This raises critical jurisprudential questions. How can legal system function effectively in the absence of institutional enforcement? Can normative authority alone ensure ethical conduct in a domain as vast, remote, and lawless as space? These questions become even more urgent as space becomes increasingly populated not only with state actors but also private enterprises with divergent interests and motivations. Following the OST, a series of supplementary agreements were formulated to elaborate upon specific areas of space activity. The first of these is the 1968 Rescue Agreement, officially known as the Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects launched into outer space. It obliges states to assist astronauts in distress, irrespective of their national origin, and to return them safely to the country of origin. While primarily humanitarian and its intent, the rescue agreement also embodies an implicit ethical principle and solidarity of humanity in the face of cosmic uncertainty. Next came the 1972 Libel Convention, formally titled the Convention on International Liability for Damage Caused by Space Objects. This treaty establishes a liability regime for damage caused by space objects. Under this framework, launching states are absolutely liable for damage caused on the surface of the Earth or to aircraft in flight, the liability under the fault for damage occurring somewhere else. The Convention provides a mechanism for filing claims through diplomatic channels and, in theories, allows injured parties to receive compensation. The liability regime, however, is largely reactive. It does little to deter harmful conduct before damage occurs and does not offer any incentives for responsible behavior. Furthermore, the requirement to prove fault in space collisions, a notoriously complex and technically ambiguous task, renders the enforcement of this convention exceedingly difficult. The case of the 1978 Cosmos 954 satellite, which scattered radioactive debris over Canadian territory, remains the most cited example of the liability convention being invoked. Canada submitted a formal claim for compensation, and the Soviet Union eventually paid a partial settlement. But the resolution of this dispute was slow, diplomatically mediated, and did not result in judicial precedent or legal reform. Another key instrument is the 1976 Registration Convention, or the Convention on Registration of Objects launched into the outer space. This agreement requires states to furnish details about their space objects, including their location and function, to both the United Nations and a public registry. While this enhances transparency and facilitates accountability, it again suffers from weak enforcement. There is no penalty for non-compliance, and many satellites, particularly those launched by private actors or dual-use systems, remained poorly documented. Of all the space treaties in 1979, the Moon Agreement is perhaps the most ethically ambitious and legally controversial. It declares that the Moon and its resources are the common heritage of mankind, and calls for the establishment of international regime to govern resource exploitation. This phrase, common heritage of mankind, resonates deeply with the principles of distributive justice and intergenerational equity. It suggests that space should not be subject to the same extractive and competitive logics that have characterized terrestrial resources use, but instead managed cooperatively for the benefit of all humanity, including future generations. However, the Moon Agreement has been ratified by only a small number of countries and is largely ignored by the major space powers. The reasons for this are manifold. Some critics argue that the concept of common heritage is too vague and incompatible with capitalist models of investment and return. Others contend that the requirement for an international regime could disinventicize innovation by creating legal uncertainty or bureaucratic barriers. Yet from an ethical standpoint, the rejection of Moon Agreement reflects a reluctance to embrace genuine global solidarity in space affairs. In addition to treaties, there exists a growing body of soft law. Non-binding agreements, declarations and guidelines that influence behavior without carrying the force of formal legal obligations. Chief among these are the United Nations Committee on Peaceful Uses of Outer Space. These include recommendations on the long-term sustainability of space activities, mitigations of space debris, and the responsible behavior of space actors. While these guidelines are invaluable in setting normative expectations, they are voluntary and rely heavily on goodwill, reputational incentives, and peer pressure for compliance. A significant legal development in recent years is the emergence of national space legislation that attempts to fill the regulatory vacuum left by international law. The United States took the lead in 2015 with the passage of the Commercial Space Launch Competitiveness Act, which allows American companies to extract the claim of ownership of extraterrestrial resources. Luxembourg followed suit in 2017 with a similar law aiming to become a hub for space mining companies. The United Arab Emirates enacted comparable legislation in 2019. While these national laws are framed as promoting innovation and investment, they also introduce fragmentation into the global legal order. By creating legal havens for commercial exploitation, they risk undermining the OST's commitment to space as a global commons. Ethically, such laws raise troubling questions. Should individual countries unilaterally legislate what is arguably a matter of shared human interest? Do such actions violate the spirit, if not the letter, of Outer Space Treaty? And what mechanisms exist to resolve conflicts between the national laws and international obligations? Another important, though often overlooked development is creation of optional arbitration rules for space disputes by the Permanent Court of Arbitration in 2011. These rules are designed to accommodate disputes involving states, international organizations, and private actors. While they represent a step towards institutionalizing dispute resolution in space law, they remain largely untested in practice. Few entities have opted into these mechanisms, and no landmark arbitral decisions have yet emerged to guide future conduct. Underlying all of these legal instruments are the fundamental jurisprudential principles that must now be reinterpreted in the context of space. Consider the maxim pacta sunt servanda, agreements must be kept. In a domain where enforcement is uncertain and treaties are often vague, how does one ensure the sanctity of international commitments? The principle of res communis, which denotes areas that belong to no one and are to be shared, such as the high seas and outer space, must now contend with aggressive commercial interests and national ambitions. Additionally, the environmental principles of due diligence and the no harm rule, long established in customary international law, acquire new significance in space activities. For instance, when a mega constellation of satellites launched by a private company increases the risk of orbital collisions or interferences with astronomical research by crowding the night sky with artificial light, is the launching state liable? Should it be required to conduct environmental impact assessments before granting launch permissions? These are not merely technical or legal questions. They are profoundly ethical, ones that demands clarity both in law and moral reasoning. In conclusion, the current legal architecture governing outer space is both rich in aspiration and limited in application. It reflects humanity's early efforts to extend the rule of law into the final frontier. Yet as space becomes a domain of routine commercial, scientific and even military activity, the limitations of these frameworks are increasingly evident. Law must evolve not only in the response to the new technologies, but in anticipation of new moral challenges. The pressing need is for legal regime that is enforceable, inclusive and adaptable. A regime that embodies both the ethical commitments and the pragmatic necessities of governing in a post-Earth civilization. In the next part, we shall return to our attention to the practical manifestations of these legal and ethical transitions and tensions by examining specific ethical dilemmas that arise in the contemporary space activities. These case studies will allow us to explore how abstract principles translate into real-world decisions, conflict, and consequences. I hope you are learning. Till then, I wish you a very good luck. Keep learning, keep shining.